discussing a case involving how evidence can be used in sexual assault trials, and a case about this law governing this issue that's recently been at the Supreme Court of Canada. So, Mr. Chan, one of the things I want to put to you is that it's really important that the complainant or victim has privacy protections. And how do we ensure that the privacy of a victim or complainant is protected if the accused wants to use records like these, like, for example, text messages?
Sure. I guess I'd answer that in a couple of ways. I guess the first point would be privacy is absolutely important, particularly for complainants in sexual assault cases. That being said, it's unavoidable to a certain extent that criminal trials, particularly criminal trials into sexual assault allegations, will get into fairly private material. The second point would be what's important is that you have a procedure in place that ensures that if the defense is going to use this material and engages unique privacy concerns, that it is probative for the defense, that it is relevant to making full and answering defense. It's not going to give rise to myths and stereotypes, and there is a particular purpose that the defense can articulate for why it's being used. There was a procedure in place before this law passed that allowed for that to happen. At common law, if the defense wanted to use these records, which raise sensitive privacy issues, at the point of use, the defense could go to the judge without the complainant present so that they weren't tipped off as to what the defense strategy would be. And at that point, ask the judge for judicial permission, and the Crown would have an opportunity to make submissions. And that gets at the core of what the criminal justice process is intended to be. That is a contest between the individual and the state, not so much a private dispute between two separate individuals. So there was a process in place before Bill C-51 passed, and our submission to the Supreme Court of Canada was that process was adequate and was doing its job to ensure that everyone's interests were properly protected.
Ms. Ng, one of the principles of our courts is that the Crown needs to lay out the case that the accused needs to meet, but the defense doesn't need to lay out their case in advance. So can you explain why that principle is so important in the criminal justice system, and your view on whether this law sort of goes against that principle?
So the principle of the right to be able to know what the Crown is alleging against you is important because it's a fundamental justice issue. And it exists because it recognizes that at the core of our system of the importance of the presumption of innocence. And so in order to make meaningful interpretation of that right, the Crown has to give you everything that they're going to use. And as a result, the defense isn't held to that same level of non-disclosure. But the difficulty is that whether or not it actually gets rid of that or erodes that right is that I would say that the regime doesn't go against the principle in such a clear-cut way because, first of all, the defense isn't being forced to do anything. There are other aspects of evidence that do require a notice requirement. It's not that everything doesn't need to be disclosed. There are certain
for
rules
example, the rape shield laws we spoke about in the last segment.
Yes, for example, exactly. And so if the regime is narrow enough in scope such that the complainant's reasonable expectation of privacy is engaged, then this regime comes forward. The accused is also not required to provide the records as part of its application. They only need to describe with enough detail for the judge to understand what the issue is. And I would just end by saying that it also begs the question that if it's a communication record, for example, and the complainant is on the other side of an email or a text message, then what element of surprise is there truly if he or she was on the other side of that communication? And so the danger of things like messages and arguments that the messages are somehow relevant because if you've accused somebody of sexually assaulting you, why would you still be in contact with them? Why might there still be fond messages exchanged? Is that then it brings in that question of how does a victim act and what is the proper way for a victim behave? And that then engages the impermissible myth and stereotype again. And so the regime, I would say that it makes sure that improper notions like that, rooted in records like that, don't end up disrupting the trial process.
Because, Ms. Ng, it's not uncommon, as I understand, for victims or complainants to remain in contact with the person who they're making allegations against.
Yes, and specifically, that's what, again, West Coast Leaf and WAVA was emphasizing, that especially when you look at complainants who are for multiple reasons in power imbalance relationships. One can envision situations where, for example, a recently immigrated woman who is dependent on her accuser on the person she's accusing to provide her with sustenance. So there are lots of power dynamics at play.